A verdict is expected any moment now in the California social media addiction trial. This case raises an important legal question. What if social media litigation is no longer about the content that people post, but about the product itself? I'm attorney Tracy Paulsen, founder of Rightful Legal. A plaintiff verdict in the California case could signal a meaningful shift in how courts evaluate liability for social media companies, because it suggests that these platforms could be held responsible not just for user-generated content, but for the way that their products are designed. This includes features like infinite scroll, autoplay, algorithmic recommendations, and engagement systems built to maximize users' attention. Legally, that distinction is important because it may provide a pathway around Section 230 of the Communications Decency Act. While Section 230 continues to offer strong protections for third-party content, it does not necessarily extend to claims focused on a company's own design choices. As a result, these social media cases may begin to resemble traditional product liability claims, where the focus is on whether a product, here, an algorithmic system, could be considered unreasonably dangerous, particularly for vulnerable users like children and teenagers. If a jury, in this case, makes it a conclusion for the plaintiff, it could indicate that certain design features are not just engaging, but potentially harmful, and that they played a meaningful role in causing injury to KGM. The broader impact could be significant. This type of outcome may influence the growing number of cases now in the federal MDL and state courts. It could increase pressure on companies to resolve claims and prompt closer scrutiny of platform design, especially when it comes to minors for social media. It may also suggest that courts are becoming more open to treating algorithmic systems as products subject to tort liability. And if that framework continues to develop, it could extend beyond social media to other digital platforms, possibly AI, and possibly other recommendation-based systems. This does not mean social media goes away in any way, but it may begin to redefine the legal boundaries of acceptable design and move the conversation toward whether user safety, especially for children, should be treated as a legal obligation rather than a business choice. If you have any questions about this ongoing litigation or your potential case, feel free to reach out to me directly at 617-821-5856. If you found this helpful, please like or share. Thank you so much.